Wiradjuri land here in Dubbo, and Finn and Ellie are on Gadigal land. We acknowledge elders past, present, and emerging through many of the young people that we're here to talk about today. So we've got an hour together this morning and we want to use it really well. We're going to start out talking about why this training and what is the Children's Civil Law Service. We'll talk about whether young people have legal capacity, what is best practice for working with young people, how do we work with young people with high needs, resources to support you to work with young people, and at the end, we'll hopefully have some time for questions. So pop your questions in the chat anytime, or at the end, put your hand up and we can have a chat, hoping it'll be a pretty collaborative session. So why this training? We are delivering this training today because children are a priority client group under the National Partnership Agreement, and young people under 21 involved in both the care and criminal justice systems are priority clients under the new civil law blueprint. Also, the division indicated in the training needs survey that they want to hear about working with young people. So we're here today to deliver. I feel very lucky to work in the wonderful Children's Civil Law Service. We're a multidisciplinary team, got lawyers, paralegals and youth caseworkers based primarily in Central Sydney, with 2 of us in Dubbo. So we've got 11 staff at the moment. Our 2 solicitors in charge are Anna Dawson and Rhiannon O'Donoghue, who job share. Then we've got 2 senior solicitors, Finn and I. We've got 3 solicitors, Larissa Day, Lisa Kobayashi, and our newest team member, Annie Archie, who joined us 2 weeks ago from private practice. Welcome, Annie. We've got 3 senior youth caseworkers, Emily Shanks, Jodie Hodder, and Ellie Formica, and 2 paralegals, Murray Porter and Vanessa DeVario. Children's Civil Law Service supports quite a narrow criteria of young people. So it's young people aged 10 to 21 who are involved in the criminal justice system and are either in youth Koori Court, in out-of-home care, or have had an out-of-home care experience, are homeless or at risk of homelessness, and live in Dubbo or Greater Sydney, and they have a civil law issue which can't easily be dealt with by another service. So as you can see, it's a pretty narrow criteria. We're a small team. We have really limited capacity, and that's why we need you guys, the rest of the division, to also be working with this really, really important client group. So one of the number 1 questions we get asked is whether young people have legal capacity to receive legal advice and instruct a lawyer. This is a great first question because it is something a lawyer must determine as a first step when working with young people. So capacity is not about children turning 14 or 16 or 18 and suddenly having the capacity to instruct a lawyer. It's something we have to decide about each individual child in relation to each individual legal matter. It might sound tricky, but it's not. The fundamental question is, can the young person understand the general nature of the legal issue or their decision? So providing instructions, it's more than an ability to express a view. It means the child is able to present their views as a considered response to the facts and circumstances of the case. So they don't need to understand everything about their legal issue or every aspect of legal procedure or substantive law. They just have to know what's going on and what the consequences of their instructions will be. So it's good to think about whether the young person understands the basic facts of the case, they understand the role of their lawyer, the role and views of other people involved in the case, so other parties and the consequences of their actions. This means a young person may have capacity to give instructions in some matters and not other matters. So, for example, a 10-year-old might be able to tell you definitively who he wants to live with when his parents aren't available, but that doesn't mean he's going to be able to instruct in the negotiation of a complex deed of release. So that's why we need to be thinking about each young person when they come in, and then be thinking about this question fresh about each of their legal matters. Assessing capacity is a continuous process. The next most common questions we get are listed here on this slide. Can I give legal advice to a child? So if you've determined the child has capacity, yes, go ahead. What type of legal representative am I? You're a direct representative. This as opposed to a separate representative or SEP rep, which may be required, for example, in the guardianship division. A direct representation model is the same model used for practitioner-client relationships where the client is an adult. A child client is owed the same duties of competence, loyalty, confidentiality, and professional representation as an adult client. A direct representative receives and acts on instructions from the child, not what the representative considers to be in the best interests of the child. And this can be really hard as a lawyer. So it's something that you do need to remind yourself about. You might be thinking, if I was them, this really isn't what I would do. And I think, you find yourself thinking that about adult clients all the time, but we do feel differently about children. And I have to remind myself about this really often. Who is the client? So we often get questions about who to open the CCMS service. The child is the client, so the CCMS service is to be in their name. Even if it's the parent who's reached out to make that first contact to put you in touch with the child is the client and the service is in their name. It's even more important with a child client than an adult client when you start your conversation to explain the role of a lawyer. It's really possible that you're the first lawyer that young person has ever come across. So you need to make sure that the young person understands that you're their advocate, you're on their side, and you're not just another adult telling them what to do. Might be good to say something like, you're the boss of me. I won't do anything unless you tell me to. And you need to stay in touch with me because I can't work on your matter unless you tell me what to do. This is letting the young person know, you're not just going to go off and just do whatever you want. Like, it's not just one appointment and then that's it, you're off. You need to let them know that they're going to need to stay in touch with you and they're going to need to keep you updated if they change their contact details. Providing advice to a young person can be hard, even though you're probably providing more basic advice to a young person than you would to an adult client. It's difficult to break that information up into bite-sized chunks. So you want to provide advice that is accurate and relevant without going into too much unnecessary detail. For example, you want to tell the young person what the law is, but you don't need to tell them the name of the legislation that makes it that way. Breaking information into bite-sized chunks might mean discussing different legal matters or different steps in the same legal matter at different appointments. And once you give the advice, it's really important to check that the young person's understood without being patronizing. So you might want to ask something like, tell me, what will happen if you don't pay your fines? And then hopefully they'll repeat back to you what will happen if they don't pay their fines. And if they don't, you can have another go at it in a different way. What's the role of a children's lawyer? Maintaining an unshockable exterior, even if you're shocked on the inside, is key so that they feel safe to tell you what it is that they want to say. Accepting that they won't always take your advice. Don't take it personally or get disappointed when they let you down, disengaged, or tell you to get lost or worse. Advocating and making their voice heard, even if you don't 100% agree with their decision, is really key. Taking instructions from a young person means taking their concerns, priorities, and relationships seriously, listening to the young person, but being clear about what you can't change. And if you've agreed to do more than one scope of work, asking them, which one of these things do you want me to do first? This helps the young person feel like they're in control of the legal advice and the legal process. And it's common that the thing that they're prioritizing is not necessarily the thing that I'm prioritizing. I think it's important to really be consistent and cognizant about your body language, using body language that's warm and caring and consistent with what you're saying, remembering that the majority of what a young person hears comes from your non-verbal communication, using simple and understandable language, breaking down complex information, and communicating with them effectively is really important. So checking their understanding regularly, breaking everything down, asking them questions, doing things in their order of priority where you can. Young people might find it harder than adults to articulate their legal issues, to explain what it is that they need a lawyer for or what it is that they've booked the appointment for. So that's why the Children's Civil Law Service has developed a legal health check. That's what I've got up here on the slide. It's a ticker box form outlining the most common legal issues impacting young people, helping to draw out what a young person might need from us. This isn't mandatory for use with young people, but it's a good option, and I wanted to let everyone know that it's there. It can be a really good conversation starter. So maybe the young person has an issue with school, but they're struggling to kind of let you know what it is. And this can help point you in the right direction. You can download it from the Children's Civil Law Service intranet homepage. So I don't want to spruce it too much, but it's a really great place to find really useful resources for working with young people. And we're going to talk about it a bit more at the end of this presentation. Okay, working with parents and carers is a real challenge when working with young people, or it can be a real challenge. They might be either too engaged or not enough engaged in their child's legal matters. Do I need to get consent from a child's parent or carer before giving advice to a child? No. The young person is totally able to come and get legal advice on their own, and they don't need their parents' consent. Should I have the child's parent or carer present when I take instructions or give advice? Generally, only if the child wants and there are no conflicts in their matter. So if I go to court and I'm there to see a young person and their parent is with them, I will say to the young person, hey, I wanted to have a chat about your legal matter. Do you want to come with me? And I wouldn't usually invite the parent or carer if they're there. If the young person says, can my mum or dad or carer or auntie or uncle come with me to the appointment? I say, yeah, if you want them to be here and you want them to listen to your advice, then that's fine. Sometimes they'll say, no, I don't want them there. And the mum or dad is saying, oh, but I want to come in. And then it's my job as the lawyer to say, this is a private matter. This is the young person's legal matter, and I'm their lawyer. So I might ask you to wait outside, please. And it's your job to advocate for their interests in that way, even though it can be awkward at times. I'm going to hand over to Finn now, who's going to talk about when to appoint a tutor.
Thanks, Brodie. So in some circumstances, it might be necessary to appoint a tutor, also known as a guardian ad litem, GAL, or litigation guardian, whose role is to provide instructions on behalf of a young person. Appointing a tutor is required if you're representing a child in a representation service, so an ELA or grant of aid, and in circumstances where a tutor is required by law. In these circumstances, it's the tutor who is your client, and that's the case in CCMS, and you act on the instructions of the tutor, who in turn has a duty to act in the best interest of the young person. So anything in relation to the conduct of a proceedings may be done by the tutor on behalf of the person under legal incapacity. I've previously had a look at the GAL, Guardian Ad Litem Handbook, which I think is put out through the Law Society. It's a really useful document and sets out the GAL's responsibilities. It's often a parent of a young person who acts as a tutor, but it doesn't have to be. And the circumstances in which a litigation representative may be appointed are set out in the rules of the various courts. So Section 3 of the Civil Procedure Act says that a person under legal incapacity in relation to the conduct of legal proceedings includes a child under the age of 18 years. So when read alongside Rule 7.14 1 of the UCPRs that says that a person under legal incapacity may not commence or carry on proceedings except by his or her tutor. That means that the tutor is required when representing a young person in civil proceedings before the local court, the district court and the Supreme Court. And in turn, a tutor cannot commence or carry on proceedings except by a solicitor. A tutor is also required, excuse me for 1 second. A tutor is also required when representing young people in civil proceedings before the Federal Court, the Federal Circuit Court and the Family Courts. A court may appoint and remove a tutor under UCPR 7.18, but a person may become the tutor of a minor without the need for any formal instrument or appointment or order of the court. So if a tutor wishes to commence an action on behalf of a legally incapacitated person, they have to file a consent to act as a tutor and a certificate signed by the tutor's solicitor stating that they don't have an adverse interest in the relevant proceedings. Conversely, there's no express legal requirement for a child to have a tutor when commencing and participating in proceedings in NCAT or the AAT. In NCAT, a GAL or tutor may be appointed on application by a party, or where the tribunal itself considers a tutor as necessary even when no one actually applies. In the AAT, there's no legislative provision allowing the tribunal to appoint a tutor or guardian ad litem, and that's presented some issues in the past here at Legal Aid. I understand that might be changing. There might be some law reform in that area. In terms of reaching settlements, a court must approve a settlement in proceedings brought by, on behalf of, or against a person under 18 years of age. And a person under 18 may settle a claim before or without commencing proceedings without approval from the court, but importantly, a settlement will not be binding on a young person unless it's approved by a court. Next slide, please, Brodie. Okay, so payments to clients under 18. If a person under 18 recovers damages or compensation, the money is paid as directed by the court, and they'll commonly direct that a sum of money be paid to New South Wales trustee and guardian to be held in trust for the child. And if a young person instructs us that they think they've got money held on trust, we can sometimes assist by contacting TAG to find out the details. And once a young person turns 18, we can also assist by helping a young person fill in the relevant forms to access money held under trust. Generally speaking, it's a tax file number and ID that they need, but it can vary. Next slide, please, Brodie. Excellent. So with respect to limitation periods for people under the age of 18, refer as you ordinarily would to the law cover schedule of limitation periods to determine whether a limitation period applies to a child or young person, just as you would with an adult client. There is, however, specific limitation period information that applies to children and young people. So in general, the limitation period of claims by children is suspended until they reach 18 years of age. So that's from a combination of Section 11(3) of the Limitation Act and Section 52. It's because under the Act, a minor or person under 18 is considered, and the language is kind of old school and inappropriate, but is considered to be a person under a disability. The Act then goes on to say that if a person has a cause of action for which a limitation period has commenced to run and the person is under a disability, so including a person under 18, then the running of the limitation period is suspended for the duration of the disability. Importantly, for personal injury claims made after 2002, the limitation period will start to run immediately if the child has a capable parent or guardian. A court can extend the limitation period if the failure to bring an action within time is attributable to an irrational decision by the person's parent or guardian when he, she, or they were a child. Where a person has, or where a young person has a personal injury claim against a parent or guardian, the limitation period won't start running until the person turns 25 years of age. So there's a few complexities there, and the team's always happy to chat if you have any questions in that regard. And there are, of course, no longer any limitation periods for claims resulting from the sexual or serious physical abuse of a child, and that's in the Limitation Act as well. Next slide, please, Brodie. Thank you. So in terms of claims against DCJ, this is an issue that comes up from time to time in the team. Young people who have spent time in out-of-home care may seek advice about a civil claim against DCJ arising from their abuse in care or DCJ's failure to remove a young person from an abusive situation. These are, of course, negligence claims that we cannot act in as legal aid solicitors. So what we should do is advise on limitation dates. So as we spoke about earlier, a negligent claim expires 3 years from when the injury becomes discoverable, and we should then facilitate a referral to a private firm who act in negligence and can recoup fees from DCJ, like Caroline O'Day or similar. And yeah, look, I mean, clients should be getting advice as soon as possible where there's a question around limitation dates, because as discussed, it can be complex. And then finally, this slide is to draw your attention to some issues that can arise from time to time around confidentiality of young clients. So by way of example, Section 254 of the Children and Young Persons Care and Protection Act makes it an offence to disclose any information obtained in connection with the administration or execution of the Act, with several exceptions. So this would include, for example, disclosing the young person is in care. In practice, it's a slightly confusing section, and the best way to ensure that you're doing the right thing when advocating for a young person in care is simply to get their consent to discuss or disclose their care status for the particular issue that you're assisting the young person with. Similarly, Section 65 of the Young Offenders Act, which is the act dealing with young people who have committed crimes, also makes it an offence to publish or broadcast the name of a child dealt with under the Act, or any information tending to identify any such child. And this section applies before or after the matter involving the child is dealt with under the Act. There's an exception where the child is over 16 and has consented to the broadcasting of his, her, or their name and information. The reasons that these prohibitions exist are really due to a need to safeguard a young person from discrimination on the basis of their status as someone in out-of-home care or on the basis of their criminal history. And I'm now going to hand over to Ellie, who's going to speak to us about best practice when working with high needs young people. Thanks, Ellie.
Good morning. Yes, I'm just going to go through a little acronym, some little millennial slang for working with young people so that it's easy to remember. Yeah, so the first thing I think is really important is to be really straight up and simple when working with young people. Then L is liaising with supports is super important. A for being accountable, and Y, keep yapping to a minimum. So being honest and authentic is super important when working with young people. I mean, anyone with any age, but I think young people in particular instantly pick up if there's any inauthenticity or if someone's not being 100% honest with them. So I think it's super important. I know in general, solicitors are incredible at being honest and authentic and realistic. So I think it's really important because, young people, might have trust issues, and then any kind of even if it's a small little lie or anything like that, they'll pick up on straight away. Simple, clear communication is really important. And I think sometimes because we're used to, there's all the legal jargon and complex language that we might forget when we're speaking, that not everybody understands that. So young people could have varying education levels or comprehension levels. And I think it's really important to use simple kind of language, depending on the young person, but in general. Flexibility maybe with communication styles. So I know all the young people that I work with don't love phone calls and they prefer texting, and then they can kind of get back to you when they're ready with a response. And then I guess sometimes it's easier for them to take in information via text than it might be over the phone. Also, a lot of young people don't really check their emails that much. So you might have to prompt them if you do send an email, and then emails you do send, it'd be good if it can be brief, because I know a lot of young people getting these long emails about legal issues are just not reading them. And then I think it's also important, as Brodie mentioned earlier, to check comprehension, because I guess sometimes we can assume that our clients are taking in all this information and they seem like they are and they seem like they're listening, but then later on it turns out that they didn't understand anything you were saying. So I think it's really important to stop and ask questions like Brodie was saying, in terms of can you repeat back what I just said, and what does that mean to you in your own words, so that they actually are getting that information on board and then able to make decisions with that. So L is for liaise with supports. And I think to make our lives easier, it's always the best if we can communicate and collaborate with other professionals that might be involved with the young person, whether that's a caseworker, a youth worker, anyone that might be working with the young person, that we're kind of able to use them to assist us with the things that we need to get done, and to kind of help with, you know, maybe bringing the young person to appointments, maybe helping follow up on tasks. So you might be able to, if with the young person's consent, send them the emails with all the legal stuff that they can kind of go through at maybe a slower pace, you know, in the community with the young person. And then also you can involve it with the young person's consent, provided there's no conflicts, the important people in their lives. I think like a lot of young people will feel much more comfortable if they can bring, say, a family member or a friend or a partner to an appointment, and are much more likely to engage and to follow up if they feel like the people that are important to them are included and are welcome. Next. A is for accountability. So I noticed one of the biggest things is to do what you say you'll do, and when you say you'll do it, because a lot of the young people we're working with have pretty significant trust issues and have been let down by adults for a really long time. So I think even if it's a little thing that, you know, maybe it's like they want to get something back from the police that's been, you know, after being in custody, and if we're able to do that for them, it really builds a lot of trust and rapport, and it's really significant. I think it's super important to be realistic and set expectations. I think, you know, some young people might have never seen a civil solicitor. They don't really know what the role entails. They don't know how many clients you have or what responsibilities you have. So they might just think, oh, you can do this, this, and that for me, and not really realize that that's not realistic, or it's going to take a lot longer than they anticipate. So I think to, be really clear with that, and then to keep reminding them of that. And then if it's things like, you know, maybe they want to make a complaint about a police officer and they want them to be fired, to maybe be like, okay, you know, you can make this complaint, but, you know, chances are they're probably not going to be fired, or whatever it is. Just that they're not kind of they don't have these kind of expectations that are never going to happen. I think it's also important that we own our mistakes, and even if they're little mistakes, I think it's so important for the relationship that you acknowledge it, apologize, and explain how you'll do better. And I think a lot of people don't do this, and so young people might not be used to it, but it's so important, you know, rather than being kind of defensive or making excuses, even if it's something little. Next. Yeah, so Y is for yak less. And that's just, you know, trying to keep it brief and I guess tailored to understand that a lot of young people, you know, might have difficulties sitting and focusing. They might have ADHD or other disabilities that maybe impact their ability to take in information. And so depending on the young person, I often find it's good to have multiple short appointments, and kind of focus maybe on one issue at a time. And, you know, obviously checking in and making sure they understand, rather than kind of a really long appointment. I've seen like so many young people sitting in appointments of a couple of hours, just tuning out, you know, when the solicitor's going through all this advice, and it's just not helpful for anyone. And then I think as well, like to focus on the young person's priorities. So they might not be your priorities or what you think is best, but I think it's so important to focus on what is, you know, something that's the most important for them at this time. So that they will stay focused and engaged. So one of the things that's really important to maintain contact with young people is to try and get as many, you know, contact details as possible, because a lot of the young people we work with, you know, might lose their phone might be seized by police or something. And so then you'll lose contact and you won't be able to follow through. So good to get, you know, whatever phone numbers they might have, or family or friends, caseworkers, addresses and email addresses, so that if something does happen, you're not just relying on one mobile number. And also, you know, in terms of consent, to maybe speak to important people in their life, whether it's, a caseworker, or it's like mum or dad, or, you know, a partner, or whoever they identify and consent for you to speak to, just so you can, you know, help with engagement and follow up with different tasks.
All right, Ellie and I thought we might do a little case study now about helping a complex young person. This could be any of the clients of our service. Hey, Ellie. So this young person presents for a civil advice appointment. They tell you they've just left out of home care. They're sleeping in their car. They want to sue DCJ and they have $20,000 in unpaid fines. Their biggest concern is getting their Nike TNs back from the police. They're really escalated and swearing and yelling, so you're struggling to get the advice across. Ellie, what should we do first?
So I think like the biggest thing when people are escalated is to try and think, okay, what is it that they need right now? And so I guess if they're they're really frustrated, like what's going on, maybe they just want to be heard. So I think if you have capacity, maybe just sitting and, if they're not too escalated, if you can sit and listen to what they're saying, and just let them have that space, I think that's really valuable, and see what, their priority is. So I guess, yeah, obviously there's a lot of stuff going on there, and there's stuff that probably for most of us would be a higher priority than the shoes. But I guess if that's their biggest concern, then going, okay, well, yeah, like we are able to kind of, consider like ways that we can deal with that, or, talk about that, that concern and the priority, and then deal with these other things later on. And I think, being led by the young person in terms of their priorities, and if they feel heard, generally people will de-escalate. Obviously, if people are, not de-escalating, then it's probably like, an opportunity to see if there's someone that can come and pick them up, or, cease the kind of contact and organize to speak to them at another time, by setting those boundaries. But yeah, I think, being able to hear someone and understand and hear their struggles is really important.
So if the young person doesn't de-escalate, we might try and rebook the appointment, ask them, is there someone I can call to come and get you? Because I don't want to make it worse by just continuing to talk at them while they're really escalated. But if this works, and they do de-escalate, then I might give them some legal advice once they're calm that I could maybe help them to get the TNs back from police, explain their options for dealing with the unpaid fines, and say I might agree to lodge a write-off application for them in dealing with their fines. I would advise them about a negligence claim against DCJ and offer to refer them to a private solicitor for further assistance. Sleeping in their car isn't really a legal issue though, Ellie. What should I do about that?
I think you just want to explore whether they have any other current supports. And maybe if not, then referring to like a local youth service or a local homelessness service, which, it doesn't mean you have to do heaps of work for that, but it might just be finding the number for like a local service and calling together with them to facilitate a referral, or, calling their caseworker that they've formerly worked with or something like that if they're in out-of-home care, and explaining the situation so they can kind of take that on board and continue it.
What if I can't find a local youth service? Like, what's the best way to try and find one?
I guess you can always, obviously Google, but you can always reach out to us, like reach out to a youth caseworker in our team, happy to like take calls and like advise of, potential services in the area that might be suitable.
Okay, awesome. When I go back to my computer to lodge the write-off application, say I realize I need some more information from the young person before I can lodge. So I call the number they've given me and a disembodied voice tells me that the number has been disconnected. What should I do?
I think luckily we've gathered all that info earlier. So we might try contacting their email address or the support people they've identified and consented for us to speak to until we can find someone that can connect with them.
Okay, I eventually get onto the young person on one of those numbers, but now they won't stop calling me. What should I do?
I think first be like, great, I must be doing something right, that they're reaching out. But then, yeah, going back to setting boundaries and expectations. So maybe reminding them of the limits of your role and what you do, and that maybe some of the issues that they're having are psychosocial, and you might need to redirect them back to the youth service that you might have referred them to, or to like their caseworker, or, a similar service that can deal with their ongoing issues.
Great. Okay, love it. Thank you, Ellie. Okay. We want to talk a little bit now about how the Children's Civil Law Service can support everyone in the division that's doing this work with young people. We are really proud of the Children's Civil Law Service intranet page. It's chock full of helpful information and resources, and it's a great place to start when working with children and young people. That's on our intranet page. I put some screenshots in here. So this is the homepage of our intranet. Got a bunch of resources specifically about working with young people in out-of-home care that I have so beautifully circled here, including the main matter types around advocacy and leaving care. So it's a good first step. If you scroll down to the bottom of our homepage, we have links to more in-depth pages on heaps of other common areas of law impacting young people, including issues with police, custody, education, identification. A lot of the practical things we've spoken about today, like the legal capacity of young people, are discussed in more detail under this heading, Young People and Lawyers Working with Children. That's like the fact sheet kind of version of what we're talking about today. And of course, the Children's Civil Law Service team would always love to hear from anyone in the division who's working with young people. The best way to contact us is by email at childrenscivillawservice@legalAid.newsouthwales.gov.au. And we have a roster for responding to that email address to make sure that someone in the team gets back to you within 48 hours of your inquiry. So we're snappy and we're keen. Reach out to us anytime. And I'm so happy to see that we have heaps of time for questions. So we are gonna move on to questions. And Finn, take the wheel.
All right. I might start by just addressing a couple of comments in the chat before we get onto some questions. Thanks, Jackie, for noting that as at October 2024, the new ART, or Administrative Review Tribunal, that's replacing the Administrative Appeals Tribunal, will have the power to appoint a litigation guardian. So that issue has been addressed, which is great. There was a question from Rhiannon for you, Brodie. What if mum or dad wants to know the content of advice that we give to a young person? Can we share it with them?
Well, it depends on what the young person wants. So I've had this situation go both ways, where the young person is really keen to have their parent involved, and they might say to you, yes, this is what I want, but can you keep my mum or dad updated about how everything goes? And then after I'm getting advice, or at each step, I might be calling mum or dad to specifically let them know what's happening with their child's matter. But I've also had it go the other way, where the relationship is not good between the young person and their parent or carer, and they might say, I don't want them involved, I don't want you to talk to them. And then it's important to be clear with the parent or the caregiver if they're reaching out, I act for Jacob, I'm Jacob's lawyer, and I'm sorry, but I can't keep you updated about their matter. And you just have to leave it at that. Does that answer your question, Rhiannon?
I reckon it probably does. Thanks, Brodie. There were a couple of questions that came through prior to the presentation that I might address before opening it up to the floor. The first was, can we refer young people to generalist legal aid solicitors in their local office, or do they have to be specialist children's lawyers? The answer is yes, young people can be referred to generalist legal aid solicitors in their local office. And we are, as Brodie and Ellie have pointed out, always ready to assist with the various questions that come up when assisting or acting for a young person. Young people can also be referred to CCLS, our team, if they meet our eligibility criteria. And I'll reiterate that is young people aged between 10 and 21 who are involved in the criminal justice system and are either in youth Koori Court, in out-of-home care, or have had an out-of-home care experience, or are homeless or at risk of homelessness and live in Dubbo or Greater Sydney, and have a civil law issue that cannot be easily resolved or dealt with by a mainstream service. The second question that came through prior to this presentation was around children's ability to enter deeds of release. It's an interesting question. In most matters, a young person entering a deed of release will already have a tutor or a GAL guardian at the time that they enter into the deed of release, in which case the tutor will sign on behalf of the young person in their best interest. In other matters, the solicitor will need to seek specific guidance because, as noted earlier, a young person can settle a claim without commencing court proceedings, but the agreement will technically only be binding on the young person if it's approved by a court. And there's a separate but related question about whether a young person can enter into a contract, and the answer, in short, is yes, they can, provided the contract is sort of for their benefit and for an essential goods or services. So this comes up from time to time with things like mobile phones and employment contracts, but it's very much a case by case basis. So do get in touch with specific questions if this arises in your casework. We've got 15 minutes. If there were any further questions, feel free to jump in the chat or just pipe up on the screen. Okay, Nicola, if the children live in the excluded areas, for example, the Blue Mountains, is there somewhere you would recommend they be referred to if they need this kind of advice? Rhodey or Ellie, what do you think if the young person in our case study was living in the Blue Mountains? How might we address that?
Yep, then they would be dealt with by their local office. So they'd be referred to, I think Blue Mountains would be covered by the Western Sydney Civil team. So a referral would go out to them and their generalist solicitors would take care of that young person.
With our guidance if necessary.
Absolutely, yes.
And thanks, Rhiannon, for piping up there. Just further on, there's a lot of detail in the part about Guardium ad litem direct rep discussion earlier, and where we need to have a tutor and around questions around capacity. Do we have all of this set out in a handy guide somewhere? We do, and it is saved on our intranet. Is that right, Brodie?
Yes, it is in a very handy guide that Rhiannon, of all people, has uploaded to our intranet.
It is there. It is there.
Yes,
Great.
it is there. So if you scroll down, I think if I can go back, this legal capacity and representing young people, I believe it's in this document at the top of what's circled here. Rhiannon, correct me if I'm wrong.
That's correct. Thanks, Rhiannon. And thanks, Michelle, for pointing out the Children's Legal Service Crime Youth Hotline that can help with referrals too.
Yes, good point. Thank you, Michelle.
Were there any other questions that anyone had? We do have a little bit of time.
I'd be really interested to know if many of the civil solicitors do find that they have young people who are referred, or whether it's mainly like older adults and it's quite rare for young people to come as clients.
Great question.
Can people please reply in the chat? Also,
Any
I'm so sorry, I
generalists?
just realized my camera hasn't been working the whole time. You just have to look at this photo of me.
I think I mean, in my experience in other teams, it was generally quite rare to provide advice and assistance to a young person, perhaps with the exception of work doing NDIS appeals where quite a few of the clients were young people. And Jackie's right, yeah. We often get young people and give advice to young people via their parents. But interested in any other views. And in the meantime, Jody has a question. Can solicitors and caseworkers still work with the clients if they enter into custody whilst you're working with them? Ellie, what do you reckon?
In our team, we definitely can. So a lot of our young people are in and out of custody, and that's a great thing about the team and the flexibility.
And sometimes it can actually be easier to contact a young person who is in custody because it's quite straightforward to set up a video conference with that young person compared to when that person's not in custody and they have their own phone that might get lost or might change numbers. So if you have a young person who's in custody, it can be pretty straightforward to get in contact with them for the purpose of advice and ongoing assistance.
I agree, Finn. It's good. And I try to frame it for the young person like, well, you're in custody at the moment, so there's not too much exciting stuff going on. So let's try and use this time to get your legal matters dealt with. And, we can be productive together during this time and make the most of it. And some young people respond really well to that, and they're happy to have someone calling them to break up the day and get something done while they're in custody.
Mm-hmm. That's right. And thank you, Jackie. Yeah, it's a good reminder that it's very important to get instructions directly from the young person and being clear that they're our client, particularly in the face of where you have a young person that has a lot of support, a lot of adults in their life, working for different organisations with competing interests. It can be really important to keep that in mind. And that's quite right, Rhiannon. The caseworkers and youth justice detention centres are generally pretty helpful in helping getting documents signed. In my experience, more helpful than the workers in adult jails, generally speaking.
Yeah, that's true. I think on the parent or carer or other adults, you can think of the parent or carer or adult who's contacting you about the young person as making a referral. So if they're saying to you, oh, Joey's had another pair of shoes confiscated by police, or Joey's got more unpaid fines. Okay, there's the referral. And now I need to contact my client, who's the young person, to confirm that. So I might say, hey, your mum let me know you got some new fines. Do you want me to deal with them in the same way I'm dealing with your existing fines, for example? And then getting that instructions directly from the young person and then acting. And you might want to say, can I let your mum know I spoke to you about this and we're going to do X, Y, and Z? And if they say yes, sure, go back to them, kind of seeing them as a referrer, back to mum. Okay, spoke to Joey, I'm going to deal with those fines. Or they might say, no, I don't want you to tell my mum, in which case you'd act on that.
Yep. Thanks, Brady. Were there any other final questions before we finish up? I think that might be it. Thanks everyone for coming along and attending, and do remember that you can contact us directly with any questions or referrals, and we're always happy to chat.
Thanks so
Ellie.
much for coming, Brady. Everyone.
Thank you.
All right, thanks everyone.
Thank you.